Thank you. Welcome back. The board just completed an executive session, so we're back in regular session now, and we will proceed with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Oh, whenever? Okay.
Oh, yeah. So this evening we have a special presentation. It's actually HIB board training done by Francis Fabre from our attorney's office. This is a training that the board elected to do to kind of refamiliarize ourselves with the current state of HIB. So we're hoping to learn a lot tonight. So thank you. You can take it away.
Thank you. Happy to be here. I'm going to give a refresher training and training for those who have not seen it before. HIB, you're familiar. Every month you get a report from the superintendent to apprise you of if there have been any HIB incidents, investigations, what were the findings, if a parent requests an appeal, you hear an executive session, you look at all of the information. So the purpose of this presentation is really going to break down HIB from what the statutory definition is to how we commonly see it in schools, to what the anti-bullying specialist's role is, and also to kind of explain and differentiate HIB from code of conduct, right? Sometimes there can be infractions that overlap, so you can have a code of conduct infraction that's also HIB, but oftentimes you'll see code of conduct infractions that are not HIB. And what does that mean? Because I know a lot of times parents may come forward and say, well, I don't understand. Why didn't you find that this was HIB? And sometimes they might think it's not being taken seriously because you don't have the label HIB. But having that HIB label doesn't necessarily mean that any more severe consequences are going to be imposed or that it's being taken any less or more seriously. It's just simply an application of the definition that the state finds and it's tracking to the conduct, right? Does it mean that it's not perhaps another form of harassment, another form of intimidation or bullying under your code of conduct, right? Because that conduct does fall there as well. So just starting with the definition of HIB. I'm going to pretend I know how to use this. Okay. So a lot of words on the plate on the slide. Essentially, when we break this down, and I pulled this straight from the statute when it says, what is HIB? And we use that term HIB, but it's harassment, intimidation, or bullying. And when we break it down, it really is going to be any type of conduct, whether it's a gesture, a physical act, a verbal statement, digital communication. So anything, right? That is reasonably perceived characteristic, right? Actual or real. And that can be anything. We have your very, typical traditional forms that we see from the New Jersey law against discrimination, right? Where it could be religion, it could be race, it could be sex, it could be gender, but it's anything. It could be the color of your hair. It could be if you're a vegetarian. It could be if you like rock music. It's anything, right, that sets you apart or anything that someone can say it kind of defines you a little bit. So anything at all. It's very, very broad. It can take place on school property, but it doesn't have to be. We see a lot of HIBs coming because of text messages or social media conduct that occurs off school property, perhaps at a rec game or a school-sponsored event. So the location, when I look at HIB, when someone asks, okay, take a look at this, what do you think? Do you think all the criteria has been met? Really, the location is, to me, a throwaway because it doesn't have to be connected to the school. But it has to have some sort of substantial disruption with the school operations or some sort of substantial interference with the rights of the students, right? So that's the connection to the school. So even though it doesn't have to take place on school property, there needs to be that nexus, meaning a disruption to the school operations or significant interference with the rights of other students. Before we get into that, right, because then you also have your impact, and we're going to get through that. I want to kind of just take some time to look at what a distinguishing characteristic is. All right. So a distinguishing characteristic, again, something that sets somebody apart. It could be their affinity for sports, right? They could be very athletic. But it has to be something that is identifiable. So in this one case against Beverly Board of Education, we had a student who was teasing him about being absent during a school-wide pizza party and made comments about him smelling bad. And so there was a contest awarded at the pizza party to the class with the best attendance record. And the student against whom the conduct was made, right here, we're going to refer to him as the alleged victim, was absent for several days during the contest period. And so the students questioned why he was absent, resulting in them calling him loser and, losing the contest. So an investigation was open, and the alleged victim was found not to be targeted for distinguishing characteristics such as race, gender, ethnicity. The board found that the smell comments were unsubstantiated. Interviews with students determined that the comment was directed towards the victim. It couldn't be corroborated, nor was a statement made regarding his smell, but a general comment of something smells bad. And when we go through the HIB investigation process, we're going to talk about evidence and collecting it. And, when we meet with, or when the anti-bullying specialist meets with the student who's accused of engaging in the conduct and the student who's the recipient of the conduct, oftentimes it's a he said, she said, and we're unable to really confirm whether the conduct occurred. Nevertheless, right, the principal usually will put some sort of measures in place. There's that record that there was an investigation. Sometimes it's a student conflict. So in this case, there was no distinguishing characteristic, and therefore the conduct that was complained of was not found to be HIB. Another situation regarded High Point Regional High School, where the students always had a history of being a little disagreeable with each other. Every few years, there would always be some sort of sporadic conflict. And in this particular case, the parent complained that one female student had grabbed the girl's arm, took her Chromebook, causing her to get in trouble. But again, there was no distinguishing characteristic, right? The anti-bullying specialist, in looking at all the evidence, could not actually ascertain, but why? What was the motivation for the conduct other than the students just don't like each other, right? So there was no distinguishing characteristic in those cases. So I said before, you have to have the conduct reasonably motivated by distinguishing characteristic. Where does it take place? Doesn't really matter, provided that there's a substantial disruption to school operations or interference with the rights of the student. So here's what substantial disruption means. And it's almost a misnomer, because substantial disruption really isn't so substantial, right? When we think of substantial disruption, we think something that's pretty shocking, that's really going to almost shut down the school, cause a student to run out of the room crying. Sometimes, yes, obviously, if you have that type of reaction, it's a substantial disruption. But a substantial disruption can also be that the student was just annoyed and went to the teacher and reported it, right? It doesn't have to be anything so substantial. There was a case in Ridgefield Park, where a staff member engaged in conduct towards a student that two other staff members found to be a little alarming, thought was highly insensitive, made a remark that would be reasonably perceived as being on the basis of race. And the students are really young. We're talking kindergarten students. So the student wasn't really so aware of the connotation of the conduct and the comment. And another staff member, in seeing how offensive that statement could be, quickly jumped in. It was like, oh, she's complimenting your hair. She's doing a good thing, right? To try to prevent the student, actually almost preventing that substantial disruption. And as a result of there not being a substantial disruption, the commissioner said, no, this is not HIB. And the argument was attempted to be made, well, if the student reports it, it's a substantial disruption because the student's recognizing this is an appropriate conduct. A staff member who has more knowledge and better judgment of how another staff member should or should not treat a staff member, shouldn't that also count? No. Nevertheless, other examples of substantial disruption, so you can have something as simple as a student reports it to the teacher, right? And HIB can have varying consequences and various reactions. So when we look at conduct that constitutes HIB, and we'll go through the impact, the effect of it later on, it can be something that's slight, as something like an insult, it was an insensitive comment, to a hostile educational environment. So there's a range. So HIB can be found even though the student reported it to the teacher, and then next class was playing with the student again, right? So you will have those situations where in one moment the student is offended, is upset. Give them an hour, they're friendly again. And we do have scenarios where you have friends, close friends who play at each other's houses, on the same sports teams, get along famously, do engage in HIB conduct towards each other at times, because they're not looking at, again, whether or not this was so significant. They're just looking at in the moment, snapshot, really. Is conduct that's happening towards one student where other students report it. So a situation where one student was being sexually harassed by a male student, and the other students felt so uncomfortable about his interactions with her that they reported it for her. Students not fully available for learning, so not being able to focus in class, missing school. There was a situation where a student was really involved in the basketball team, loved going to basketball practice, but was being bullied. And so as a result, didn't want to go, didn't want his mom to attend the practices, just felt really embarrassed. So noticeable shifts in students' behaviors, engagement, you want to look at those types of examples. And then, did I just turn it off accidentally? Okay, sorry. And then finally, the effect. Okay, so just quickly to repeat the earlier criteria, and this is criteria. These aren't factors, meaning everything has to be met in order to be found HIB. So you need conduct, anything that is reasonably perceived as being motivated by distinguishing characteristic, takes place pretty much anywhere, but either substantially disrupts the operations or interferes with the student's rights. Okay, and lastly, you need to have the effect, even though substantial disruption seems to be an impact, but another effect. And that effect is one of three, can be all of three. The first one is be the type that a reasonable person would know under the circumstances would either harm the person, their property, or their emotional self, or reasonably do so, right? Will reasonably have the effect of doing so. And we're looking at this in the perspective of the person who's engaging in the conduct. What would a reasonable 7-year-old know? Would a reasonable 13-year-old know? Would a reasonable 17-year-old know? And then the other one would be have the effect of being insulting and demeaning, and that's one of the more easier effects to kind of prove, or create a hostile educational environment, and that's going to be something much more significant and severe, right? You look at the law against discrimination, when we think of a hostile work environment, severe or pervasive, essentially that's what you're looking for here. So conduct that is repetitive, that's ongoing, but it could be severe. So it could be a physical assault, right? That's pretty severe, that will cause the student to find that the educational environment has become hostile or abusive. All right, so what is insulting and demeaning? So one student telling another student or calling another student fat, saying that the student has a double chin, making comments about the student's shoe size and the clothes. And as a result, the student not wanting to come to school, right? Not wanting to take his medication because he feels like if he doesn't take his medication, he'll lose weight. So that's the substantial disruption too that you're seeing, not wanting to go to school, even though the student did go to school and the attendance records didn't show it. The fact that the parents are reporting like he doesn't want to take the medication, we're having such a hard time getting him to school as a result of this incident. And so the Commissioner of Education found that those types of comments were insulting and demeaning, and the distinguishing characteristic was appearance, weight, and appearance. Physical or emotional harm. In a Chatham case, we had a student with a peanut allergy, with a nut allergy, and the students happened to be friends in earlier grade levels, kind of their friendship fell apart later on. The reason why that's important is because one student, BM, who engaged in the conduct, knew about the nut allergy of the other student. They're at the cafeteria table. The student, BM, puts a cashew in his hand and puts it towards the face or the person, the student who has the nut allergy. The BM indicated in the moment he forgot, but when he extended his hand with the cashew, the other student's response was to jerk back and say, "Hey, are you trying to kill me?" And reminded him of the allergy. At which point that student took the same hand that he had the cashew, rubbed it on the student's lunchbox and water bottle. And so one of the arguments was, well, they didn't mean it. He didn't intend to cause harm. He forgot in the moment. But it goes back to how that conduct was reasonably perceived. And the student with the nut allergy reasonably perceived that as being motivated by his nut allergy. In his mind, I'm familiar with the student. He knows of my nut allergy. I also gave him the reminder during that time, and he persisted in the conduct. And so the commissioner found that a reasonable person would know that presenting a cashew to a student with a nut allergy would place the student in physical fear of harm, reasonable fear of harm. This is a student who needed an EpiPen if he had an allergic reaction. And so whether the student realized that offering him a cashew would trigger the student to experience an allergic reaction is not relevant under the reasonable person standard, right?
So in this case, the school district first found it not to be HIB?
In this case, the school found it to be HIB. The ALJ found that it wasn't HIB because they found, and it wasn't really so much a determination on the substantive basis. The ALJ found that, well, he didn't really mean it. It wasn't so severe. Don't you think that labeling this as an HIB would be pretty harsh? And the commissioner said that is not our judgment to make. We have to just apply the criteria, the HIB definition to the conduct. And in doing so, the commissioner affirmed that the conduct was HIB.
What does ALJ stand for?
Administrative law judge. So when it goes to the hearing before the Board of Education, if a parent appeals, it goes to the administrative law judge at the Office of Administrative Law. The ALJ will have like a fact-finding hearing. We'll look at the evidence, and then it will go to the Commissioner of Education. And we'll talk about that a little bit of what that appeal and the HIB process looks like. But really, when you're looking at that from the ALJ standpoint, they're not essentially reinvestigating, right? They're not taking apart your HIB investigation, taking all the students and staff members who were interviewed and calling them and making them testify in order to really prove whether or not the district got it right. What the ALJ is looking at in that instance is they're going to look at the report. Was it thorough? Was it timely? Was it complete? Did you follow the procedural requirements of the Anti-Bullying Bill of Rights Act? Substantively, does the report have evidence or enough information to find that the conduct that was investigated meets the criteria under the law? And really, they're looking at it from an arbitrary, capricious, and unreasonable standpoint. So, if there's facts that could lead to either conclusion, whichever conclusion the board makes, it's not going to be arbitrary, capricious, and reasonable. It's that if the facts are so one-sided and the board finds another way, in the other way, then it would be deemed arbitrary, capricious, and unreasonable. And the parents who are appealing have the burden of proof, right? They have to show that your investigation, that the anti-bullying specialist investigation, the district's finding, and the board's upholding of that, or whatever finding the board is, the board can reverse or modify as they choose, that was arbitrary, capricious, and unreasonable. So that's really the standard by which the ALJ was supposed to apply, not whether or not he agreed with the law. But the commissioner, reviewed it thereafter and said, wait a minute, let's remember, what the review here is. And our role is to really make sure that the board applied that definition under the law. You're welcome. So, hostile educational environment. So one student calling another student short, loser, dumb, no good in basketball, and further telling the student that you're going to become a drug dealer. So the comments were motivated by the distinguishing characteristic of height, sports proficiency, and intelligence. And the ongoing comments were found to have created a hostile educational environment. Student indicated that he felt bad, sad, scared, and insulted. And the students who were interviewed also corroborated how the student felt. So in this case, it would be something that's more pervasive, not so severe, but pervasive, ongoing. So intent doesn't matter. A lot of times we'll see in the investigation interview summary statements, the student reported, I didn't mean it, I was just joking. In fact, in one of the decisions where the student was making fun of the student's weight and appearance and he didn't want to take his medication anymore, the ones who said, it's just trash talk, we're just joking around. I was just joking. Well, it doesn't matter, right? It doesn't matter if the offender was joking. What the standard is, or what the definition of HIB is whether a reasonable person would perceive that the conduct is being motivated by, and usually that's going to be other student witnesses. That's going to be also the student, who's the recipient of the conduct. And we think about what's the age, the maturity level, what are they learning in school? Sometimes we get the argument of, that's too young to really know, but there's a lot of education happening in school about, how to treat others and respect and all of that. So you'd be surprised what a reasonable 7-year-old or 8-year-old will know, depending on the circumstances and what the nature of the comment is. In this case, the Webb versus the Verona Board of Education, there was a teacher who was essentially trying to tell one student or discourage the one student from taking an honors class, indicating, well, really reconsider. The parent took that as the teacher treating the daughter or her daughter differently on the basis of her disability. And so the teacher pretty much, and so the school found that it was HIB, acknowledging that the teacher inadvertently made a comment that she did not intend in how it was received, but based upon all of the information, it was HIB. The ALJ again said, nope, not ALG, not HIB. She didn't intend it, and the commissioner corrected it and said, no, remember, if we look at the criteria, we don't have to look at intent. It's just how it's reasonably perceived. Okay, HIB versus student conflict. So you have your code of conduct policy. We have HIB policies. Really what's happening is if a student engages in conduct, it's going to already be a code of conduct, right? That's really the driving force of your your student expectations for conduct and interactions on school. So if someone calls a student a bad name, it's already going to be addressed under your code of conduct, right? Immediate. It's code of conduct infraction. The next question is whether it is also HIB, right? Bless you. And so, if it gets reported by a parent, they're pretty much just thinking HIB because it's common. That's what they're hearing. There's the sole policy on HIB. So the parent will say, I'm reporting what we think might be an act of HIB committed against my child. And of course, an HIB investigation will be open and we'll go through some of the procedures on when a preliminary determination can be made. But starting just with parent reports, I think HIB, they're not thinking code of conduct potentially, right? And so you engage the HIB process. Likely the principal is also going to be addressing this as a code of conduct because they overlap essentially. But the code of conduct is more general, right? It's you should not punch another student. You should not make an insensitive remark. You should not, generally. We're not looking at the motivation or why they said it. Just the student did this. It was inappropriate. It violated the code of conduct. It's an infraction. The student gets a detention or counseling or whatnot. When it's looked at whether or not it's HIB, applying the criteria that we just went through, the same discipline may have already been found to be sufficient to address the conduct. So just finding that it's HIB does not make it more serious. It just means that the conduct just also happens to meet the criteria of the state law, and now you have to report it as HIB. So HIB versus student conflicts, pretty much student conflicts is an unproductive way to resolve an argument, right? Two students just don't like each other, they never have, and there's that constant back and forth, right? There's no distinguishing characteristic. There's no motivation other than I just don't like the student, or the student said something in the moment that hurt my feelings and I said something mean in return. You're looking at conduct that is kind of two-sided. When you have more one-sided conduct, then we're looking more whether or not this is bullying. But again, it has to meet the HIB criteria. But it could still be bullying under your code of conduct. So what's a student conflict? Student conflict is girls not being invited to a birthday party, glaring stares, name calling, right? But no distinguishing characteristic. These girls just don't like each other. Thinking that you're a better athlete than somebody else and saying, well, the captain of the team doesn't like me and she's not giving me the position I want or giving me enough field time, and it's because I'm a better athlete. Well, we've seen that sports proficiency can be a distinguishing characteristic, but there has to be something in the HIB evidence that supports it, right? It can't be a subjective opinion that I'm the best athlete in the world and therefore anything that bad happens to me, it's because of this distinguishing characteristic, when no other student or teammate also views it similarly, right? At that point, they just found it to be a student conflict. And where that one student tried to say, hey, this was just trash talking, it's not HIB, sometimes that is true. So we had a student in Jefferson, there was like a group message with different girls, and they were pretty much calling each other abhorrent names. And one of them was the N-word, and the parent of the one girl saw the text message of one student calling her daughter this horrible name and filed an HIB. The district investigated it, saw that they were all pranking each other, and found that it wasn't HIB for that reason. It went to the Commissioner of Education, and the board's determination that it was not HIB was upheld. All right, so
Why was it not HIB?
because they were all pranking each other, or they're trying to be who can be more offensive, who can call each other the worst name. They were not, remember, you need the substantial disruption and
Intent does not matter,
right. But here you had no substantial disruption. No student was offended by it. They were all equally engaging. It was something that they all signed on to do. So it just happened to be the parents saw the text, didn't understand. It was like, oh my God, this is horrible. Rightfully so. But the girls themselves were like, I wasn't bothered doing that. That was their reaction. And the commissioner found that when the girl did testify too, she was very matter of fact about it. She's like, yeah, that's what we did. Wasn't affected at all. So reporting, investigating. So when a parent or a staff member or another student sees or learns of an alleged act of HIB, it gets reported. The Anti-Bullying Bill of Rights Act sets forth a particular timeline, right, for when matters must be reported to the principal, ultimately in writing, when an anti-bullying specialist is assigned, how long the investigation must take. So it can't take 10 days unless there's new evidence that comes up that necessitates the investigation. But there's also there used to be, before the law was modified, provided that the board put it in their policy, you can make a preliminary determination, the principal could. The regulations and the statute was amended to now kind of just authorize it, even if it's outside of policy, even though the policy should have this in it. Essentially what it is, a parent comes and they report conduct that they think is HIB. And when you look at the facts, right, assuming all, not the facts, when you look at the reported information, assuming everything is true, they still does not meet the HIB criteria, the principal can say, you know what, I'm not going to open up an HIB investigation, but I'll investigate it as a code of conduct. So they have the right to do so. They have to notify the superintendent. The superintendent will notify the board when those determinations have been made. The parents have the right to appeal. They can say, I don't agree with you, principal. I would like to appeal this to the next level. It would go to the superintendent. The superintendent would hear it. If he agrees with the principal and the parents wants a further appeal, it would go before you. And you would look at the information and you would hear from the parent and you would determine whether or not you think it should be investigated as an HIB or if it can continue to be investigated as a code of conduct. If you find that it should be investigated as an HIB, it goes back to the anti-bullying specialist and your 10 days start from there. Investigations. All right. So I said they must be completed within 10 school days. Again, they can be extended if there's new evidence. And at the end of the investigation, it's reported to the superintendent, who's going to then look at all the information, maybe make any final determinations as to discipline, remedial measures, things of that nature. Whether or not additional information has to be obtained, but ultimately the superintendent will then forward it to you. Before it gets forwarded, during the investigation process, you have anti-bullying specialists who are going to look at the report of HIB and they're going to say, okay, what do I need for my investigation to make sure it's thorough, timely, and complete? And some of that would be, okay, what evidence? Is it social media? Have the students provided any snapshots of the messages or the post? What about text messages? Is there any email? Is there video of the hallway if there was an altercation in the hallway? Who are the witnesses? Is the lunch table? Who sat at the lunch table? So essentially they're trying to get who, what, where, when, why, right? Who was around? Who can I interview? Who has this information? And there's no real order to an anti-bullying specialist investigation. They can meet with whoever they want to first, but generally they're going to meet with the person, the student who was affected by the conduct, the student accused of the conduct, witnesses. Parents may sometimes give statements, whether it's through email, whether they make an appointment, but sometimes parents may have some information as to how it's affecting the child, maybe some prior relationship of the children. I always find that that's important to investigate if these students used to be friends or not, because how do we know if it's a student conflict if we don't maybe have some of this contextual information? Preservation of evidence, so they're going to make sure that any evidence that you do have, whether it's text message or whatnot, you're going to get the consent from the student because they can't go through their phones, but they can ask. And they're going to schedule the interviews with the students when they can. Again, you have that 10-day timeline. Things that I recommend, they want to know the who, what, where, when, why. That's how we're going to get whether or not the HIB statute was met. So who was there? Who did you see? How did you feel? Why do you think that happened? If you can, depending on the age of the student, written statements are ideal, but they're not required. The law does not require any particular method of investigation. Other than that, the anti-bullying specialists actually conduct an investigation that is tailored to elicit information to help us uncover whether or not the conduct meets that HIB. So I have some sample questions generally for anti-bullying specialists when we give this presentation. Again, the who, what, where, when, why. If a student has an IEP, usually the case manager is present with the student. If it's a sensitive topic, you might want to ask the student to write down the statement instead of verbally speak. You might assess whether or not you want a female in the room or a male, again, depending on what's being alleged. Students with disabilities are also subject to the Anti-Bullying Bill of Rights law. There might be students with developmental disabilities, and one would argue, well, how do we then say that this student really was motivated by distinguishing characteristics that they really understand? And that's really going to come back to the factors too, right? What's the age of the student, the developmental disability? What are the other students' perception of the student's understanding and cognitive abilities? There was this one case where there was a student with autism and she was significantly impaired and she was in the female restroom with other girls. And she kind of poked her head under the stall and, said hi. And she would do that to everybody who came, every girl who came into the room, in the bathroom. If she was in a stall, she would poke her head in. Again, not appropriate, but these other girls kind of knew she wasn't targeting them for any reason. It was a game that she thought was fun and they understood. So in that context, a reasonable person would not perceive the conduct as being motivated by gender or whatnot. So we're going to look at different types of information, but typically if a student, regardless of disability, has a basic understanding that what they said was insensitive or wrong because previously they were counseled or they acknowledged that it was wrong, but they did it anyway, they would still be subject to consequences. It may be completely different from a typically developing student who engaged in the conduct, right? It may be counseling, maybe there might be some program modifications, maybe some training or whatnot. So the consequences would vary, but you would still get an HIB finding nevertheless. Again, if all of that criteria was met, and it's going to also be dependent on how it's received by the alleged victim and other students as well. So the superintendent notifies the Board of Education of the investigation results, and it happens right after the investigation is completed. So your first board meeting after the conclusion of the investigation, you learn of it. You don't take any action to affirm, modify, or reverse. You can receive it, and that's it, right? So then after you learn of the information, the parents receive information within 5 days, an information letter of sorts, which essentially tells them what was the nature of the investigation, what was the findings of the investigation, their right to have an appeal before the Board of Education, even if they agree, right? Sometimes they want to go before the board to say, I support this decision. I think you guys got it right. And we've seen that sometimes. And so that information has to be sufficient for them to really understand why the decision was that it was HIB or it wasn't HIB. But you also have student confidentiality laws. So when communicating that information to parents, typically you're going to use some generic terms. Another student, right? Your child was reported to have engaged in an act of HIB against another student. 3 student witnesses were interviewed, including the student who was the recipient of the comment, right? You're not actually identifying the students who were involved, but you're giving the parents some information so they understand what happened and why that determination was made. So let's say the parents do request a hearing. There is no formal rules for the hearing either, right? This is an opportunity to cross-examine anyone. It's an opportunity for the parents to come before the Board of Education and provide you with information, right? At this point in time, they will have had the information letter. They would have had some understanding of the basis for it. Maybe they met with the principal and even have even more information. They could bring witnesses. So if they want to bring their child, if they want to bring a friend who wants to provide some sort of character evidence, fine. They could provide information. They have to be provided with a reasonable amount of time to do so. The board really is to hear from the anti-bullying specialist or the anti-bullying coordinator to get information about the investigation so that they understand, how the determination was made. And with all of that information, the Board of Education is going to come to a decision to affirm, modify, or reverse. And so after the HIB hearing, the parents have the right to appeal. Some tips for HIB hearings. If a parent requests one, I usually recommend that the other parents are contacted, right? So they have an opportunity to come before the board during the same time. It's just more expedient for both families so that you don't have a back and forth and a re-review of the meat of the matter. The anti-bullying specialist under the law, right, is permitted to attend if you so like, to provide you with an overview of what occurred during the investigation, who the anti-bullying specialist spoke with, impressions, all of that. And so after the Board of Education hearing, the board is going to issue through its board secretary or superintendent a letter that pretty much notifies both parents or staff members can be accused of HIB as well, of what the determination was, whether the board decided to affirm, reverse, or modify, and why. So you're almost like building onto that information letter, because that first information letter to the parents is going to have the overview of the district's findings. But now you're going to add to it, and you're going to provide, get a little summary of what the parents kind of presented. And then you're going to add, what was the board's rationale and justification for affirming, reversing, or modify. So again, this whole point is to preserve the rights of the parent and or staff member who might be accused, their due process rights. So they are involved, they understand what happened, they have a meaningful opportunity to participate in the process, whether it's to oppose or to support the determination that was made. If it is appealed by the parent, it can be appealed to the Commissioner of Education within 90 days of them receiving that board determination letter, or within 180 days from the incident to the Division on Civil Rights. If the parent does appeal, we had to address what that standard is. It's not a reinvestigation, but it's really a review of the information that was available, that was, procured through the anti-bullying specialist and made available to the board, and from what you kind of made that decision. Any questions? I know that was a lot of information.
It was, but I mean, it was, I think, super helpful. I'll open it up, questions. We can start anywhere. If anybody has an immediate question, jump in, or we can go down the line. Looks like, did you?
Yeah, Francis, thank you. That was super helpful. I think a lot of information we knew, obviously, but it's always good to hear it again. And I think you always kind of look at it differently each time you get a different presentation. So I appreciate it. My question is specific to the HIB versus student conflicts. So you mentioned a few times if there was no distinguishing characteristics. That seems easy, right? But let's assume there's a conflict between two students, and let's say each individual act clearly would have been HIB if it wasn't back and forth. Is that a conflict, or is that two HIBs?
It could be both. I know it's such a lawyerly response, but really that's why with an anti-bullying specialist, I always recommend that they ask, the teachers and the students about the relationships of those students. Are these two students who always have a conflict with each other? Have they had this conflict for years? And are they always fighting about something or another? Or, and is this a student who makes conflicts with everybody? Or is this a student who really just picks on this one kid? And this one kid had enough and said an unproductive comment back. And now we're going to look at, well, maybe the one comment was HIB, but the response comment wasn't HIB, because the response comment was that student's way of saying back off, but didn't do so in the most appropriate way. So that could be a situation where you have a student conflict on the one hand, who the kid is just trying to end the back and forth, but HIB on the one. It could be where both students just said something mean because someone took the pencil and he got aggravated, so he called the student a name and the other student called him a name. Probably is a student conflict. But again, you need more history. And that's why these are so fact sensitive. And then you're going to go through the rest of the HIB criteria, right? So if it was a conflict, was there substantial disruption? Did these students, because if they're always annoyed with each other, did that really have an impact on them? Other than this kid is just so annoying versus, what he said was really hurtful because of, whatever the distinguishing characteristic or the word that was used at the time. But they can be very gray. And I think when you go back to the arbitrary, capricious, and unreasonable standard, that's what you're looking at. And the more information that you have, the better, right? Because sometimes these are such gray matters and you are doing a back and forth and back and forth and back and forth. And that's one of the examples where if the evidence is so uncertain, right? Because it could support either determination, it's not going to be arbitrary, capricious, and unreasonable. But if everything is one-sided, then it would be. So, boards struggle often with HIB decisions because we are dealing with young kids, and sometimes it's difficult to get into their minds. On the one hand, educators know kids really well. They kind of, especially the teachers, they learn their personalities, they learn their quirks, they learn when they're really upset or when they're not, and they're just kind of being a little silly. But sometimes kids can also do a really good job of disguising things. So it can be hard, but that's where you kind of have to look at making sure enough witnesses. So in that scenario, look at the other witnesses in the class and ask them, do these kids always fight? what's your perception of their relationship? Are they friends? Are they not friends? And you might get those other kids say, oh my God, they're always fighting every day. One of them is doing something to the other. So that's where you're going to look for like more of that extraneous information.
So can you, and if you can't now, you certainly, I mean, so two things. Number one, where in the law does it state that, what you just described? And number two, do we have any case law? Because when I look at the case law that you quote here, these aren't HIB for other reasons, right? No distinguishing characteristic. That's separate from a conflict, or, it may be a conflict also, but the reason for no HIB is because no distinguishing characteristic. The other one is that it was, I'm trying to remember, it wasn't substantiated, right? Couldn't be substantiated. And the other one was that there was no detrimental effect on the school. So like, to me, those reasons why they were not HIB really weren't directly contributed to the student conflict. I still am not clear. I don't know how everybody else feels on these student conflicts. If they're clear, like I said, if each individually would have been HIB, I just don't see how they're not both HIB. But we've run into these before, and I just don't see in the law where student conflict comes in, and or case law. But you probably have more case law than, it's probably stacks of it.
So there is case law, and I can't think of a case though right now, but definitely the Department of Education, the Anti-Bullying Bill of Rights Task Force has put out guidance that they have, a lot of examples of what student conflict is with the back and forth. And they do make a point to kind of separate out those student conflicts from HIB, because they're trying to, I think, find that balanced understanding that sometimes kids are going to just have that back and forth, and not every incident of disagreement between students is going to be HIB, or rise to the level of maybe even a code of conduct infraction if it's just two students who don't have the maturity yet of learning how to resolve their differences or disagreements. And I think you'll see a lot more of that with the younger students than with the older students, because now saying something that's really insensitive and inappropriate might not be HIB for the lack of distinguishing characteristic, but you're probably going to find a code of conduct infraction.
Doesn't that sound like New Jersey's trying to put the separation of power? In other words, because like that's not in the New Jersey law, where it definitively is in many other state laws with HIB, where the differential in power within that conflict is an issue. But New Jersey doesn't have that, but it sounds like they're almost trying to put it there. Like if there's no differential in power, meaning it's a conflict back and forth, it's not HIB, but the law specifically does not call out the differential in power.
Correct. That's only in the Department of Education guidance where they talk about this imbalance of power, right? Some factors to consider, the imbalance of power, but it's not actually the statutory definition. So it's something to consider, but ultimately you might have an imbalance of power, but you need to have all the other criteria met under the statute, or else if you have the imbalance of power, but you're missing some of those elements, it's not going to be HIB. Yeah. And I mean, power can be also subjective too. Right?
You hit it right on the head, right? And this is where we always start spinning around. Like this is, the other pieces I think are easy. And in the case law you cited, kind of makes sense. This is the area where we run into the most trouble. And this is where we start to.
I think the commissioner and the Department of Education is trying to remove some of that subjectivity and really kind of fall on the evidence. There was one case before the commissioner where you had two female students who had like a romantic relationship. They had broken up and they were in a music class, and one of the girls was singing in choir, I think it was choir, and the other girl plugged her ears and said something kind of like, And so when the anti-bullying specialist went to investigate it, she learned that these two students happened to be previously involved. And I guess she made the assumption that there was that imbalance of power. One student had more social standing, and also based upon that, they said it was based upon gender and social status. But when the commissioner looked at the HIB investigation, the report, and the evidence, where did you find this? You are supplanting your opinion, right, and your subjective interpretation or perception over these girls' relationships and status than what the other students and actual involved students actually said was the reason for their disagreement. So they're saying, what are the students telling you? What is the evidence telling you? And I think to your point, let's not kind of implant our own perception, but rather, what are the students saying?
What's the, when cases go to the commissioner or to ALJs, what's the main thing they're looking for? Are they looking at specifics and second guessing you on your determination, or are they really looking at the process and making sure that it's not arbitrary and capricious and you're following some type of a code or
So
plan?
they're looking at your procedure for sure, because under the ABR, you have, right, how many days before it's reported, how long did the investigation take. However, those procedures were put in place really to offer due process to the parents and the accused staff member, let's say, right? So if you do deviate, let's say you go beyond the 10 days, or you don't make the board doesn't make the determination right away, or perhaps the investigation might be a little flawed. Ultimately, if there was enough information and the ability for decision to be rendered and the parents were kept involved in the loop, they're not going to find that procedural violation or those deficiencies amounted to a violation of due process or a substantive violation of HIB. If the procedural violations are such that the parents really, or the accused staff member, couldn't participate, didn't have their ability to provide information, maybe the anti-bullying specialist hardly interviewed anybody and came to a conclusion, the commissioner could remand it for a new investigation or a hearing. But typically, it's going to look at where there was sufficient due process, right? There might be a procedural deficiency here and there, but where there was sufficient due process that was confirmed, they're going to look at the substance of that determination, and they're going to look at the reports, and they're essentially going to defer to your decision unless it was so one-sided, arbitrary, capricious, unreasonable. But that's where you fall back on, let's look at the investigation report. Was it thorough? Was it complete? Was it comprehensive enough that we could say we had enough evidence to really believe that, it was based on a distinguishing characteristic, that it was reasonably perceived to, put a student in fear of harm, something like that. So you have to make sure that evidence is sufficient.
So I had a couple questions. The first one isn't really an HIB criteria question, but some language regarding imbalance of power came up in one of our HIB reports, and Dr. Forte thought this would be a place to discuss that. Basically, it said that there is not an imbalance of power as evidenced by the alleged victim making comments back to the alleged perpetrator. That seems problematic to me, to define imbalance of power based on whether someone fought back or not.
Agreed. And I think that's why it's not part of our statute. I think that imbalance of power could be whether you're physically larger, whether social standing, could it be your role? So whether it's a staff member to a student, I think you're if it's a staff member to a student, there's going to be that power dynamic there. But I think balance of power, it's not always easy to measure.
Right. And I guess my issue is to define imbalance of power, whether someone fought back or not is not really a great definition. Would you agree?
Agreed. Yeah,
Yeah.
absolutely.
Yeah. My second question, it sort of piggybacks off of what Mr. Anderson said, is I'm noticing a pattern. I don't really think that we have a huge HIB issue. Like, I don't think we make huge mistakes, or any mistakes for that matter. But I'm noticing that a lot of times we're getting these HIB reports. We're looking at the checklist. There's all this evidence for, distress and this and that. And then in the final instance, there's one line that says, well, we found out it was a back and forth, so it's not HIB. And that seems problematic, because all the evidence seems to be it's HIB, and then this one line counteracts all that, and we're not getting a lot of the other information. It seems like that could be an issue for us at some point. I don't know. It just seems a little odd to kind of have it set up that way. I was wondering your thoughts on that.
I think without more, it's hard, but I don't know if these are young students where, they're upset because, they're having an argument in class. And so it is distressing in the moment, but it's also part of maybe the learning. If it's a pre-K program, a kindergarten program, part of the learning that's occurring in the classroom with the teacher, and how to handle your emotions and to communicate effectively, and maybe, coping mechanisms. So I think if it's maybe 16-year-olds who are having meltdowns in the classroom and it's a back and forth, maybe. But again, is the HIB criteria being met? It could still be a back and forth without the distinguishing characteristic.
Yeah, I think from my end, I'm just wondering if our, like, the way in which we're reporting it on the report itself should be there should be more information about the reason we came to the conclusion that it's back and forth rather than being so top heavy with, because the student's distressed, this is a HIB related statement and all this stuff. And then there's just a couple lines, like a line or two. And just from a recording standpoint, I'm just wondering if it would make sense for there to be more information on the report itself about how that conclusion was drawn.
Yeah, I see what you're saying, but keep in mind also HIB investigations that are being reported, and the whole it's really to help tee you up for if there's an HIB appeal, and when you make the determination to affirm, modify, and reverse, where there is a student conflict and you know it's a student conflict, that kind of ends the scenario for HIB. Doesn't mean you can't ask questions in executive session for clarification, but you also want to be mindful of making sure that you're not getting into like the day-to-day of any kind of student discipline or health matters or, anything like that. So I see what you're saying. I think ask for clarification, but as far as, whether or not a lot more information regarding a student situation that's been found not to be HIB should be provided, I think you just want to be careful with how much information is being reported on that, because we want to make sure that, the role of this is to report HIB, yes, no, here are the reasons why. Okay, great. A parent appeals or a staff member appeals. Now you get a copy of the redacted report. You get more information. You're now getting the understanding of what's happening. But in order to affirm that second time around, even when there is no HIB appeal, you have to have sufficient information to be able to affirm. So, definitely ask those clarifying questions. It could be just they're trying to balance the amount of information that's going to not cross over that, HIB school day to day. But ask the question. I would always see clarification, but it could just be the reports, are trying to be just succinct to what is HIB.
I have a question about students with disabilities. How often do you find parents try to use disabilities as an excuse to try to, what's the word I'm looking for? Let their children sort of get a pass because they have a disability. I mean, is that something you find common with other districts? Like, is that a case that you hear often, or because I think there was one case where there was a potential IEP involved with a potential student, but it seemed like she knew the difference, or he or she knew the difference between what was right and what was wrong, but yet continued, and it affected. And I think it was deemed as HIB. But seeing that your slide here addresses students with disabilities, is there how much protection is given to students with disabilities? I guess is sort of my question.
I can't say that I find parents using a student's IEP status to kind of defend or excuse the conduct. I think that I think parents sometimes don't understand the HIB definition. And I think, HIB sounds really harsh, right? You get this HIB infraction, first time it gets in your file, and every time after it's going to stay with you. And, it seems like really significant and severe. And if you were to exclude HIB, let's say it was never enacted, there's no anti-bullying bill of rights, but you still have the code of conduct, and that student received counseling or detention, I think the parent would, may still make those same arguments to say, but are you sure? Because they may not have understood. And the parents, I think, aren't there with the teachers and the administrators every day to kind of see, well, no, your student really understands interactions. Like, they're pretty friendly. They're more savvy than you think because we are engaging with them every day. So they know, right? We have a sense of, we think he knows or she knows what he was doing or saying. But I think sometimes parents are not seeing their children in that light at school around all these kids and interacting with staff members. So they may also just not really think that their child did. But I also see parents come and they will acknowledge that their student, has their child has a disability. And, they'll really more kind of say that the other student knew the disability and maybe their child was the victim. So I don't see any more than maybe other parents. Like, my kid was really young. They were 7 years old. What a 7-year-old would know that this was wrong. I think, parents try to defend their kids where they can. I don't think it's really one more in any type of student. But as far as, students with disabilities, that's why I said it's very fact sensitive as well, because again, going back to like, just like whether it's a student conflict, what's the relationship between the students? Depending on the age of the student, the other children may know that that child may have difficulties with social interactions. And so if that child or the student does say or do something, they're not going to have the reaction that they would have if maybe a typically developing peer made that comment or engaged in that action. So then in that situation, it may not be HIB because you're not going to have substantial disruption. So it's fact specific. Mm-hmm.
Anybody else? Go ahead. Ben.
I'm still stuck a little bit on the intent does not matter because, and the offender does not need to know that they offended somebody, right?
Mm-hmm.
And I'm surprised that we don't have more HIB cases because somebody could be carrying a picture or a book that could be somebody could take offense, right, to it. I'm just surprised that, and even in the original definition, it says reasonably perceived as being motivated either by any actual or perceived characteristics such as blah, blah, blah. Motivated, right? And motivated versus intent does not matter. Struggling to, connect bridge the gap. But I think it's a case by case. So far, we have not had incidents where we've had this I didn't intend to do it, it happened, right? And I think that may come up at a later time.
I think also the substantial disruption is a big piece, even though, right, the substantial disruption doesn't have to be so substantial, right? A simple act of just reporting it is enough. You may find that a lot of students when they are joking, even though intent doesn't matter, the other students know that they're joking, whether or not it's a nice joke or whatever. They may not report it because in the end, it didn't bother them. So it's not that the conduct isn't occurring. It's just not affecting or substantially disrupting the students that they are finding that it would constitute HIB.
That's correct. I mean, it's the emotional state of the person receiving that information, right? So suppose somebody carries a book, Mein Kampf, or carries a picture of a lynching, right? The person carrying it may not understand. I mean, this is egregious examples, but there may be subtle examples. You don't know what the receiving person feels like.
Mm-hmm.
So it could be substantial disruption because it's emotional state, right?
Yeah.
So at that point, how do we resolve it? So
yeah, no, I understand. I think a lot of schools since this law have been doing education every year in school all around the clock about appropriate interactions, and I think those students who are charged with HIB and if they're learning, like, oh, wait a minute, right? If intent doesn't matter, then even though I was joking around, I have to be more sensitive to what I say and what I do. But that's almost like the workplace, right? When you think about hostile work environments and such, we might find our conduct to be acceptable because we're joking around with one coworker, but we're not thinking about how our conduct or comments might be perceived by somebody else in the office. And we give anti-harassment trainings very often, and you see this overlap, right? And unfortunately, sometimes it takes that employee to have to complain before another coworker then realizes, oh, maybe my jokes weren't so funny. But some coworkers, it won't affect them. Some coworkers will. So it's almost like that in a school. But with school, you're dealing with so many children who are still learning how to appropriately interact. So you almost have a lot more examples, unfortunately, in schools. And that's why I think the law also recognizes, when we think of the law against discrimination, that we are dealing with schools. We're not dealing with workplaces. Nevertheless, schools are where we teach students about the appropriate interactions. But there is a little bit of that flexibility in that students will make mistakes because they're learning.
Francis, just to clarify, for the definition of HIB, has the effect of insulting or demeaning any student or groups of students or creates a hostile education environment for the student. So it's or, not and.
Well, you have three. So you has insulting or demeaning, or it's a type that a reasonable person would know under the circumstances would cause physical or emotional harm or harm to the property, or would, could, or create a hostile educational environment. So it could be one of three, it could be two of three, it could be all of three. If you have a really egregious conduct, it would probably be all of three.
Okay, but any one of those
Any
would
one is
qualify for
sufficient.
law. Okay.
And so the insulting and demeaning is typically the one that is the easiest to find, right? Because you say something insensitive, it's not going to be, create a hostile education, but it's insulting and demeaning. And that could be your, a name calling where the student reports to the teacher because they just did not appreciate it. It may not lead to a suspension because it's not severe, but it's a detention or counseling or something. It's still going to be HIB.
Thank you.
Thank you, Francis, for coming. I've learned a lot. This was for me pretty much because I'm the newer member and haven't gone through some trainings yet. But to speak to Mr. Anderson and Dr. Moore's gray area, right? And we have had a couple of gray area HIBs where we were kind of on the fence with a lot of different, is that or was that, or I think we see it from a parent lens or an adult lens when the kids a lot of times will say, nah, it wasn't a big deal. It wasn't that bad. And that's some of the HIBs that we've been getting. We're like, no, that's a pretty big deal. And so I just want to make that point that we see it, and that's where we're trying to separate like our subjectivity of this is a big deal, this is a problem, that if that happened to me, I would not like it if that happened to me. But we're looking at elementary school children who might not have that lens yet. And that's what we're teaching them. And that's what they're trying to give them, a better understanding of how to speak to one another and how to respect one another. So, but I thank you for coming. I've learned a lot.
Yeah, no, you're definitely not the only board that struggles with HIB, especially during hearings where I've been in HIB sessions that are 3 hours long. I've been in HIB sessions that had to carry over into multiple meetings because even though it's not a super complicated case, you're dealing with young kids or it's very hard. Is this HIB or not? And, you don't want to make the wrong decision. You know that there are, this becomes a record in a student's file, but it actually shows me that school board members and, all these communities that I go to really take this seriously.
Everybody good? Well, Francis, thank you very much. Again.
You're welcome.
So,
Oh, that's on my, okay. I don't know. I think that's still on.
thanks. Have a good holiday. Take care. Thank you. Same to you. All right, Doctor, you're up.
Okay, just a quick wrap up of our Valley View athletics for the fall. We had a successful year. Both boys and girls won a playoff game. Each advanced to the semifinals. The girls cross country team placed third in the county championships, and the boys came in 11th. Intramural flag football is underway, and winter sports tryouts begin next week. Wrestling opens up. I think the sports already started last week. I'm just reading from behind. Wrestling opens up with their first home match against Mount Olive on November 30th. Basketball starts December 5th with the boys home and the girls away versus Memorial. And that's it for my comments.
Okay, thank you very much. Dr. Cullis, your turn.
Thank you. So we did receive that high impact tutoring grant in the amount of $115,000. So right now we're just working on the bidding or the RFP process with the contractors and planning on rolling it all out by start in January. And then I don't know if you saw the article, but the U.S. News rankings came out and Valley View ranked, having those numbers, 79th out of 695 public and charter New Jersey middle schools. So congratulations to them. and we're really excited about getting started with the tutoring services. This concludes Assistant Superintendent's report.
That is great. Great news. Congratulations and thank you. I did have one question. If you don't have the number right now, I know we passed October 15th, and if I was in the report, I apologize. But what was our official enrollment number? And again, you don't have to answer this question right this second. If you
It's
don't
right
have it
around
now.
1,700. I don't have the exact on
Yeah,
my top of my
okay.
head.
If I and again,
it's-
if it was
it's
in
1703, yeah.
Perfect. Thank you. Okay, moving on. Damaris, it's your turn.
Just one comment. The state had provided a lot of grants to many districts, including the ESSER 2, ESSER 3, and they had been auditing as well. These grants are federal monies, and they are going after schools doing many audits. And the district has been selected to be audited in February 2024. So we'll be preparing for that audit, and we'll keep you appraised.
Well, that's quite an honor that they bestowed upon us. Thank you.
Dino, I have a correction. It's 1705,
Okay.
according to the report we have.
Okay, thank you very much. Actually, and I'm going to ask you, James, a question again, not for right this second. I'm curious when the last time we were above 1,700 enrollment.
Right away. Right, James?
Yeah, I mean, last year, by the end of the year, I noticed that we were,
No.
up-
Yeah,
oh, I'm sorry,
you know what I mean?
previous years.
Yeah, like
Oh.
I want to compare apples to apples. When was the last year on October 15th we were above 1,700? But again, I don't need this answer right now. I'm just saying.
The more important point is that, well, not more important, but another point is just the demographic study. We're already off. We're 2 years in, and we projected 1675 and we're 1705.
Right.
So and we don't need to go off on a tangent, but
No, but it's a
point
fair,
well taken. Yeah.
it's a good point to, oh, yeah, absolutely. Because that's what more than a percent, right? That's close to what, 2% or 2% difference? Am I doing my math right? Anyway.
Yeah.
Yeah, it's over two, a little over 2%. Yeah. Okay. Anyway, just want to keep these numbers in our heads. Okay. Go ahead.
2013, 2014,
2003. Okay.
That was a good year.
10 years ago. Actually.
All right. Appreciate that. Okay. Moving on. We are going to go to our first public discussion section of the evening. These are any matters germane to the district. The exact rules and specifications are in the agenda, but if you would like to either approach in the chamber and announce your name and address for the record, or if you're online, unmute yourself or raise your hand and you'll be recognized. I'm opening up our first public comment section at 8:41 p.m. Okay, seeing no one online and no one in the chamber, I'll give it a couple of more seconds. But we'll go ahead and close the first public comment section also at 8:41 p.m. And we can move into the main part of our agenda. New business action to be taken. I'm sorry, old business action to be taken. Mrs. Adelis, can I ask you to move us through these items tonight?
Sure. So I move the following resolutions have been recommended for approval. Certify that November 2023, after review of the Secretary's monthly financial report and upon consultation with the appropriate district officials, to the best of our knowledge, no major account or funds, to move to resolve the A, reports from October 2023, the Treasurer of School Monies report and the Board Secretary report, the education reports from October 2023, HIB cases 23-24-02, 23-24-03, the attached district calendar for the school year, and then the minutes for October 9th and October 30th.
Do we have a second?
Second.
Thank you, Mr. Anderson. Any comments or questions on these items? I'll just remind board members, if you were not in attendance on those meeting dates for the minutes, you can just abstain.
Please forgive me. I haven't looked at the calendar, but I did have a question about the calendar last month, so I just need to open that up.
Mr. Kim, you had a question in reference to the meeting calendars.
Oh, forgive me. Okay, this is the school district calendar.
Yes.
Okay, thank you.
The calendar, just so you guys know, as typical, I meet with all the superintendents from our regional district. We all look to make sure that we have the calendar as close as possible. The big one that changes every year is to make sure we have the one for spring break together. And this spring break calendar works to include Good Friday in the week, as well as Passover. And it also provides for a day after Easter to that can be used for a snow day.
If we don't use snow days next year, then do we plan on finishing the school year earlier, or are we going to take like an extra weekend, 3-day weekend off during the school year? Do you have thoughts on that already, or just curious?
If we don't use them, we typically take it off at the end of the year. But there's a limit to that because we also have to work with Mars Knolls for middle school graduation. So it could be a combination of the two.
Got it. Thank you.
You planning a vacation already?
I'm hoping we finish by June 1st.
You can hope.
It just,
Go ahead.
it's actually funny as we're here at, Thanksgiving week. Steve, one of the things I was actually thinking about was, if there was any possibility in the future, clearly not for 24, 25. And as I look at the calendar, I don't really have an easy way to do this outside of not giving NJEA convention, which I'm pretty sure is not allowed. But it'd be pretty cool if we just gave the entire week of Thanksgiving off as a week off, because we're already 2.5 days into it, So anyway, it's 3 more days you have to figure out. But I don't know if it's even ever possible, but it's kind of a cool idea because if you think about a vacation, you could take a whole week vacation in November.
It's interesting you say that because I know some districts around here do actually do it, right? I think
I don't know anybody that does that week. I know them that do the week of NJA convention because especially the ones that have election day on Tuesday, they don't come back Wednesday, and then they just get everybody off Monday. So it's the whole week. But have you guys seen the week of Thanksgiving off? I haven't seen that.
I have not.
I thought I did last year, but I don't remember which district. If I find it, I will let you know. I thought I remember hearing about it and saying, "Oh wow, that would be really cool," but I don't know how they did it. But I'll try to find it.
I'm trying to shave 2 weeks off the school year, not add more.
No. I didn't say I didn't want to elongate. I was trying to figure out a way to squeeze it in. Because if you think about it, if you actually gave those 2 NJEA days and combined those with Thanksgiving week, right? You can't take them away. But I'm just saying, if you could, yeah.
They're contract. Those are
Yeah,
contractual.
I know. I'm not saying we do. And I know we give the extra day for Memorial Day weekend, which I like because it gives you flexibility towards the end of the year. If you ever need it, you can pull it there instead of adding a day on the end of the year, which has been a nice flex spot. We haven't had to use it, I don't think, ever, but it's nice to have it just in case.
And it's pretty good. Now we have 7 days to work with because one of them is the day after Easter, which would be the first one we would take back. And the second one would be Memorial Day. And then after that, we'd have to start taking days from spring break. Right. We haven't had that in a while. We've been doing the opposite. So we'll see.
Yeah.
I'm also trying to figure out a way that you can get Super Bowl Monday off.
All right. On that note, if there's nothing else, roll call, please.
Mr. Anderson,
Yes.
Mrs. Sedalis,
Yes.
Dr. Aruna Jitasan,
I will abstain from the meeting minutes on October 9th and yes to the rest.
Dr. Moore,
Yes.
Mr. Kim,
Yes.
Mr. Cass,
Yes.
Mr. Capello.
Yes. Okay, moving on. New business action to be taken. Dr. Moore, I'll ask you to move us through personnel, please.
Sure. I'd like to move the following resolutions under personnel. Under number 1, we have retroactive pay for teachers chaperoning the Halloween dance on 10/20, and instructional aid chaperoning the Halloween dance. We have in-house clinician 1 day per week and 5 days between 1/2/24 and 1/10/24. And we have cash in for vacation days for the vice principal. And then items 2, 3, 4, and 5 are leave of absences. Item 6 is a DEA sidebar agreement. Item 7 is substitutes for the district, teacher and in-house clinician. And Dr. Forte, I'm assuming that because the in-house clinician is on here, that we haven't gotten a clinician from St. Clair's, and this is the workaround.
Do you want me to answer it now, or do you want to move it all and then I'll answer?
I'll second.
Oh, sorry. Yeah. And then we have under E, new hire part-time for 23-24 school year. And number 8 is the paid leave effective November 16th.
Mr. Cass, are you okay with those additions?
I will second again.
Okay,
Make it
thank
official.
you. Thank you. Now, Steve, go ahead.
Okay, so we did have, St. Clair's does have a person starting for us on January 1st. So it's basically taking the person we have now and allowing her to work 1 day a week for us and to sub when needed. If you recall, we were down 3 this year for a short time. Actually, it wasn't that short. It was a couple weeks. And the students have weekly, sometimes multiple in a 1 week sessions. So they're hard to make up. So rather than going through what we went through already, I feel confident, and this staff member feels confident that she would be able to fill in, and allowing her to work 1 day a week kind of keeps her involved in it. And then we'll readjust and see where we're at for next year. But we want to let the new St. Clair's person come in. That's why I have 5 days with them to get, kind of assimilated together. And then our person, Stephanie, will move to a 1 day a week and fill in when needed.
Any other questions on these items, including the addendum items?
And one other thing, our St. Clair's people work 4 days a week, so it does leave 1 day uncovered. And that's why I did the 1 day a week. She'll do the day that's uncovered and try to fill in a little bit.
Okay.
There's just a clerical thing. It went from 6 on the agenda to 8. So I'm assuming that that's a typo and should be 7, unless there is a number 7 that.
There is a 7 on the agenda.
Forgive me, I was looking at the wrong section. So yeah.
Okay. Okay. All right.
Can I just add something? Steve and Sandy, can we add to the IMP agenda at some point for a committee meeting, just mental health supports, and do we have enough? What else can we do? Just a general kind of update maybe on kind of where we stand. That's all.
I think maybe we were talking about doing this. Maybe we'll have Ms. Johnson come to the next IMP committee and maybe update us on that. What do you think, Sandy? Is that okay? We'll have Grace do that.
Yeah, next one or whenever it is. Doesn't have to be necessarily in a couple weeks, but whenever you're prepared for it, I'd be interested in kind of hearing about it.
Thanks.
Nice.
Mr. Anderson, that's for the students, right? Not the staff. Mental supports for the students.
That's kind of what I was referring to, although actually, ironically, Dr. Forte and I think were forwarded the same email about some training, resiliency type stuff that I think Dr. Forte was going to kind of take a look at least talk to the person who was sent over. It was a citizen in town who had a contact in person they knew that had been working on some staff training, I believe it was, but you might be able to speak a little more to it.
Yeah, we have a call set up with that person coming up in the next couple of days with Sandy. I thought you were talking about board mental health. I'm sorry. I got to change that.
You're not fixing that quickly, so I wouldn't worry.
It's only 45 minutes for the committee agenda.
All right. If there's nothing else, let's go ahead. Roll call, please.
Mr. Anderson,
Yes.
Mrs. Sedalis,
Yes.
Dr. Aruna Jatasan,
Yes.
Dr. Moore,
Yes.
Mr. Kim,
Yes.
Mr. Cass,
Yes.
Mr. Capel.
Yes. Okay, moving on to instruction and program. Mr. Anderson, I'm going to ask you to move us through these items tonight.
Sure. Under instruction program, I'd like to move as a block items. Number one, work with his workshops with expenses. Number two, which includes the board, the attached field trips. Number three, the attached nursing service plans for 2023, 2024. Number four, which is the board approve a student from CCM to observe during the 2023, 2024 school year. Number five, which is the board to approve the Valley View Viking Connections Club to attend the Sussex County Miners baseball game. And then number six, which is that the board approve the following high school students, which are listed on the agenda, and teachers from our Hills Regional District to work with some of our Valley View 8th grade art students on November 30th.
Second.
Okay, thank you, Mr. Anderson. Thank you, Mr. Kim. Comments, questions?
Steve, what's I apologize, I don't know this, but the Valley View Viking Connections Club. I'm not familiar with that.
The mentors, right? Isn't it the mentors?
Right. I think it's the peer mentoring program for our life
Okay.
skills students.
Oh, excellent.
It's like some of the life skills students that mentor some other kids.
Excellent.
The other way around.
Yep. Understood.
Got it. Okay. If there is nothing else, roll call, please.
Mr. Anderson,
Yes.
Mrs. Sedalis,
Yes.
Dr. Aruna Jatasan,
Yes.
Dr. Moore,
Yes.
Mr. Kim,
Yes.
Mr. Cass,
Yes.
Mr. Capello.
Yes. Okay, moving on to policy revisions. Sorry, let's flip this over. Dr. Aruna Jatasan, would you care to move us through these policies for tonight?
Sure. If there is no objection, I'd like to move the following policy revisions, all of them for second reading adoption. Note that there are two for abolition, which is P 8540 school nutrition program and P 3432 for sick leave. There are two that are new, which is regulation 3212, regulation 4212 for attendance. And the rest I'll move as a block.
Second.
Okay, thank you. Comments, questions on these policies for second reading and adoption?
I just want to highlight in 5111 is now updated to reflect a new law that does not permit the superintendent to allow students to finish out a school year free of charge. And that's per the new state law. So I worked on it. I worked on the changes with Francis to make sure that it represented the law, but it's been a practice that we've done to be flexible with people, but the new law does not allow it.
Thanks. Thank you for calling that out. Okay. Any comments, questions? Okay. Seeing none. Roll call, please.
Mr. Anderson,
Yes.
Mrs. Sedalis,
Yes.
Dr. Aruna Jatasan,
Yes.
Dr. Moore,
Yes.
Mr. Kim,
Yes.
Mr. Cass,
Yes.
Mr. Capello.
Yes. Okay, moving on to finance. Mr. Kim, I'm going to ask you to take us through these items tonight.
Sure. I move to approve Section D, Finance. Number 1 is the list of checks as seen on the agenda. Number 2 is to authorize the use of a competitive contracting process for the High Impact Tutoring Grant, whereas it is recommended of the School Business Administrator Board Secretary to seek proposals from qualified providers for the following contract: High Impact Tutoring Services. Now therefore be it resolved, the Board of Education, according to the statute listed there, authorizes the use of the competitive contracting procurement process to enter in a contract for high impact tutoring services. I also want to call to the board's attention to the addendum. There is a number 3 that the board approved the attached contract for non-resident student tuition for the remainder of the 2023-2024 school year, contingent upon receiving a signed contract and deposit by 9 a.m. on November 22nd, as stipulation in the attached contract. This contract does not include transportation.
I'll second.
Okay, thank you, Mr. Kim. Thank you, Mr. Cass. Any comments or questions on these? And I just want to again congratulate on the awarding of the grant that's supporting the high impact tutoring. That's fantastic news and great work. Okay, if there is nothing, no questions, comments, roll call, please.
Mr. Anderson,
Yes.
Mrs. Agelis,
Yes.
Dr. Aruna Jatasan,
Yes.
Dr. Moore,
Yes.
Mr. Kim,
Yes.
Mr. Cass,
No on the milk fund, yes, and everything else.
Mr. Capello.
Yes. All right, thank you. Moving on to operations, Mr. Cass, I'll ask you to move us through these items tonight.
Under Building and Grounds, we have 3 items on the agenda and also 1 on the addendum. Starting out with 2.1, I'm asking the board to approve the attached change order number 2 from the American Roof Maintenance for the Riverview Elementary School repair project in the amount of $12,500 funded with the Maintenance Reserve Fund. Item 2.2 is to approve Baco Construction Company for the Lakeview Elementary School asbestos abatement of duct, vibration collars, and pipe elbows project, the amount of $12,900 funded with the Maintenance Reserve Fund. Item 2.3 is to approve the attached contract for the purchase of land located at 46 Nicole Drive, Denville, New Jersey. The contract price is $600,000. The appraised value. The purchase is contingent upon attorney review, inspections, the New Jersey Department of Education approval. The purchase will be funded with capital reserve funds per chapter or subchapter 14, reserve account 6A:23A-14.1, reference 01. Under the addendum, item 2.4, I'm asking the board to approve to publish an advertisement for bid solicitations for the sale of the following old maintenance equipment. Number 1 is brand new little, age 20 years old, located at the bus garage. Number 2 is an enclosed trailer, brand Danzer, model Morrison, year 2013, located at Lakeview School. Item number 3 is zero turn right on mower, brand is Toro, model Z Master 74272. That's also at the bus garage. Number 4, lawnmower, brand Craftsman, model 22, location at the bus garage. Number 5, water cannon reel, brand water cannon reel, also located at the bus garage.
Second.
Okay, thank you, Mr. Cass. Thank you, Mr. Kim. Comments, questions?
For the items that we're going to advertise, we did send an email with these items to the township to see if they would like any of them before we advertise it, just to let you guys know.
Yeah, I had 2 questions. Number 1, what exactly is a brand Doolittle?
That's a snow removal lawnmower type of equipment.
Okay. And number 5, that water cannon reel, is that a reel with the actual cannon on it that shoots water?
That is exactly what it is. It should water to the field, but we have not used that in a long, long time. And it's
Yeah.
just in storage right now.
So we had a lot of rain this year. Not a lot of lawn irrigation was used anywheres. But a couple of years ago, Hub Soccer bought the township several high-powered water cannons to water the fields. They eventually just went into disrepair. They weren't used, instead of testing them in February or March, when they needed them, they didn't work. So I'm wondering if that's something that we should, is needed for the Valley View field is irrigated. Do we do anything when the other ones brown out at the other schools?
No, we don't. We don't water the other schools. We don't. The only field that we prepare for athletics, our athletics, is Valley View. And just so everybody knows, these pieces of equipment haven't been used in as long as I've been here, because we outsource the maintenance of our grounds, and they're basically just sitting there. So we maintain them, but they're not getting any use at all.
And then I'm assuming is the other equipment like the mowers, is that a similar thing that we're not using them because the outsource? I mean, okay.
Exactly.
And we did offer to the township and the DPW in case they were interested as well.
When you offer it to the township, it will be free of charge, basically, right?
I don't know. I just felt like when I saw it, we should probably ask them if they're interested in it first. Maybe we can work out some kind of arrangement with them before we sell it to a private party.
Okay. Any other questions or comments? I do want to just say again, congratulations and thank you for the quick turnaround on the purchase of that property. It is, I think, a good addition to that piece of property we already own. From I think, Steve, from when we found out that the property was available until this purchase agreement is in place, we're talking a couple of weeks, right, altogether. So good move, quickly.
Yeah, it did go pretty quick, and it worked out somehow, but it was a good deal. I think for us, it's a great deal for the town.
Well, and thanks to the town for communicating, right? That was initial communication from them, so we appreciate it.
The realtor I'm working with is setting me up to get these alerts like once a week on properties that come available, industrial properties and vacant land.
Yeah, thank you. I was going to bring that up and go to the cause, but this is as good a time as any. Yeah, we had talked about just making sure that we don't miss out on potentially, available properties. So good. Thank you for that.
Even neighboring properties to our existing schools, right? Because I remember at one point there was a possible discussion about a property neighboring one of our schools. So,
I mean, my personal opinion is anytime a property comes up, especially if it's adjacent, we should definitely look at it. We should give it serious consideration. Obviously, future boards can, decide what they want to do, but my feeling is we should always be looking.
There was one that came up, and it was all swampland. Literally all swampland along the river by the bus garage. That was the last one that came up, and we passed on it because it was swampland. Didn't think anybody could really do anything with it. So, but this one seemed like a good property. But I asked him to put me on an alert for any properties that are 5 acres or more in Denville, as well as any properties that are industrial in the town of Denville and all the adjacent towns. That would be for a possible bus garage down the road in a different location. Just to have the information.
Cool. Okay. If nothing else, roll call, please.
Mr. Anderson,
Yes.
Mrs. Aidelis,
Yes.
Dr. Aruna Jatasan,
Yes.
Dr. Moore,
Yes.
Mr. Kim,
Yes.
Mr. Cass,
Yes.
Mr. Capello.
Yes. Okay, we are at good of the cause. Any discussion on committee reports, correspondence? We'll get to our discussion items momentarily about figuring out some highlights. And I think we're going to talk a little bit about the presentation in December, but anything to start on the committee reports? Any questions or comments on that? Anything we should talk about?
You're going to talk about the space in a second, right?
In a sec, yeah. I figured we'd just kind of go down, yeah. But yeah, I mean, if there's nothing specifically about committee reports, then let's continue on. General good of the cause items, anything anybody has they'd like to bring up? Feel free.
I just want to thank the PTA and the administration for putting on wonderful Veterans Day shows across all schools, Valley View, Riverview, and Lakeview. I was lucky enough to go to Lakeview. It was a wonderful show. The students did a great job. And then the luncheon for the veterans was tremendous. So I just want to thank the PTA for putting that on and the students for performing.
Yeah, I'll second that. I had the opportunity to go to Valley View and Lakeview, and obviously different programs, age appropriate for both, but both were really well done, and the students, as we would expect, did a phenomenal job at both, respectful and appreciative, and really a great program.
Very good, thank you. Go ahead, James. Looks like you have something.
Yeah. Do you want me to talk about the presentation for next board meeting?
Absolutely. We can do that for sure. For this
Sure.
December 11th.
The committee is prepared to, the Space Considerations Committee is prepared to make final recommendations during our next December meeting, or during the December meeting. Just as a FYI, that meeting is actually going to be held in the community room. I met with Ricky today to work through the technology stuff of the slides, and I discovered that we're going to be having our board meeting next door. So we have some interesting findings. I mean, I think everyone is sort of getting the gist of what our recommendation is going to be, but we'll wait till the next meeting to present that information. I did have a question, but before I did, I also wanted to echo Dino's comments about the tutoring grant. That's phenomenal. I also wanted to congratulate Valley View on, Dr. Cullis, was that 59th place across the 79th, forgive me. So 79th on that newspaper standing. So, but the Denville Green Team, they're going to be presenting also during that. Is that correct?
We'll do the green team first. They're going to probably be about 15 minutes, just giving an update on what type of green activities we have going on. They're pretty excited about what they're doing. I think that it's, when we lost the one teacher that went to Maine, right? Everybody was like, wow, that was a pretty big person in the green department for us. But this group is taking it on and maybe even taking it to the next level. So I was pretty happy. They have that partnership now with, what's that place by St. Clair's? The Oaks. They have the partnership with the Oaks now. They're doing that. They're still collecting plastic bags and trying to get Trex benches out of it. And it's been pretty good. Yeah.
Very good.
Mr. Kim, can I make a correction? The December 11th will be in this room. The January 22nd will be in the committee room.
Okay, so then forgive me. It's the I guess our meeting will be here then. So okay, great, thanks.
Can I just bring up something quickly about that meeting? I know I've received some interest from the community on that meeting, which is great because I think it's really important for them to be involved in the process and understand kind of where we are. One of the things I think would be beneficial is I had a few people ask me about how to get on the meeting remotely. Can we have the slides shared like you would at a presentation? Like, for instance, with Francis presenting today, you can't see the slides. Yes, they're posted somewhere online, but I think like you would do at a normal presentation, like share your screen so you can actually see the slides instead of seeing the video would be kind of beneficial if you were
So-
watching it from home.
So yeah, the reason why I met with Ricky today is to actually address that specifically. So we tested the equipment. I will be sharing the slides from my laptop, and it will be presented like a Zoom meeting or a Google Meet, where the slides will be on the forefront. They'll be able to see the slides as I scroll through all the slides. Absolutely.
You know, there's really no reason why I want to just do that all the time. It's really a matter of just having a process in place to do it. That's why.
Yeah. Right now, like I can tell you that I'm logged in and I don't have the ability to share my screen. So you just have to make sure that they give you the ability within the meeting to share it.
Yeah, that was specifically the one aspect that I found as well when I met with Ricky, and we found a workaround. So it'll be.
I agree with you, Steve. I think I was watching on my screen. You can't see any of that presentation from Francis. So really beneficial. We can just share the screen and be able to show the slides whenever we do a presentation.
Yeah, I'll work on that with the tech team.
Cool. Thanks. Very good. It's a leap forward, James. See, you're pushing us forward. Nice. I like it.
By the way, side note, in those conversations, people were asking about how they can go back to old meetings, and it was great to be able to say, you can go back like, I don't know, 8 years and watch any board meeting on YouTube. They were like floored. They were like, really? Like, so it was nice to be able to say that and be able to point to the fact that our YouTube channel just holds everything there. So thanks for bringing that to us a long time ago, but I think it's beneficial.
The old way was some tapes somewhere that we had. So I mean, somewhere. I don't know where, but it was somewhere.
And I will tell you, at one point, I forget, there was something before I was on the board. I had a question. I asked for the tapes to be sent to me, and it was impossible to hear anything. It was-
The video
yeah.
was
The audio is not good, so it's great. We've come a long way, and I'm glad we've worked pretty hard. And we're one of the few districts locally, or at least I know, maybe probably in the whole state, that really present and live stream our meetings and interact with people. Steve, that may be something to bring to school boards for next year if they're looking for a district that's kind of between our YouTube channel and between our like live meetings where people can interact with us from home. I know it's controversial for a lot of other boards, but I think it's beneficial if people are interested in learning how we did it. So
If I could do that virtually with a bag over my head, I'll do it.
I was going to recommend that Dino did the presentation.
Very nice. Very nice. Yeah, no, I think that's a really good call out for sure. I mean, we are still in Denville, I think, the only elected board that has that. So we've been doing it for a while and we're still ahead of the curve.
All right, highlights. Good. You ready?
Yeah.
Ready for highlights? Here we go.
All right.
BOE approved the purchase of a property adjacent to the current board property. That's all for now. HIB training, grant for tutoring, space considerations presentation December 11th, and green team December 11th.
Sounds good to me. Anybody have any other opinions on that? That seems good.
I just have
see
one
the-
thing from the rec committee.
Go ahead.
This is a big weekend coming up in Denville. As you know, we have the Friday night open houses with all the merchants in town, entertainment and all kinds of things going on. And then also on Sunday, the holiday parade, formerly called the Christmas parade. But yeah, we've had debates at that
This weekend.
at the rec committee
Thanksgiving weekend.
Thanksgiving weekend. Yeah. And they got the lighting of the holiday tree over there, and Santa Land opens up. I mean, that's just a big thrill for the kids. And then you see somebody marching in the parade that looks like me. It's not my evil twin brother, but the rec committee just twisted my arm and beat me up. I have to be the grand marshal this year.
Woohoo! Wow. All right, then we have to.
I'm still fighting them over having to wear that sash.
We'll have to come out and take a lot of pictures, Don. Don't worry. And then Saturday, I believe, is Small Business Saturday, and I know that the high school is sending the chorus down. They're caroling throughout the town on Saturday. So basically, yeah, every day this weekend, I think you've got stuff going on if you want to come to Denville. I have one more housekeeping item. We are fast approaching the end of the year. We have one more meeting. I would ask everyone to think about for 2024. If you're interested in board leadership, give that some thought. We will be electing new president and vice president. So if you'd like to have, if you have any questions about that, please feel free to reach out to Mike or I. It's a wonderful experience. It's a lot of fun. So totally enjoyable. You get paid a ton, so I would highly recommend it.
Yeah, your statement is official, right? So we get paid a ton. Should be on the next
Yeah,
board
exactly.
agenda meeting, please.
A literal ton.
A
Yeah.
ton of what?
Exactly. We'll just leave it there. All right. If nothing else, let's move on. We have open comments, our last open comment section of the evening. The same rules apply. They are outlined in the agenda. I will open up this second public comment at 9:19 p.m. Steve, while we're pausing for a sec, we do not have need for an executive, right?
No, we do not.
Okay.
And there's no one on the
Yeah.
virtual.
Okay. Okay. So seeing no one on online or in the chambers, I'm going to close this public comment section at 9:19 p.m. We do not have need for an executive session this evening, so I'll take a motion for adjournment.
Motion adjourned.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? All right. Seeing none, we are closed at 9:19 p.m. Thank you, everybody.